Hi, everyone. Hello, everyone. My name is Rochelle Lee, and I am the IP Education Program Manager for Elevate IP. Welcome to International Filing for Startups. This is one of many sessions in a subject-focused series. We're excited to run this session today. We're hoping you gain valuable insights and in the process also help us to continue to develop and improve our educational offerings for startups. So before we give you a short breakdown of the program and introduce our speaker, we'd like to play our Communitech land acknowledgement.
Communitech acknowledges that our hubs are situated on the Haldimand Tract, land that was granted to the Haudenosaunee of the Six Nations of the Grand River, and are within the traditional territory of the neutral Anishinaabe and Haudenosaunee peoples. As participants in today's event, we are coming together from many different places. We encourage you to learn about and acknowledge the land from which you participate. We will never stop fostering an anti-racist environment to create a place and space where everyone is free to be their whole selves. Our commitment to building a community rooted in inclusion and equity will never waver, and it will mean listening and learning as we go. Everyone on our team and within our community receives the same respect and opportunity regardless of age, ethnicity, gender, culture, identity, beliefs, or language.
Okay, I'd like to take a moment to encourage everyone to reflect on the land beneath you, acknowledge its Indigenous history, let this awareness inspire a commitment to respect, understand, and preserve the rich heritage of this place we call home. So just a quick breakdown of Elevate IP here. Elevate IP is a federally funded program designed to help Canadian startups understand, manage, and leverage their intellectual property. Communitech, along with our partners North Forge and Invest Ottawa, deliver the Elevate IP services and supports to startups in Ontario, Manitoba, and Saskatchewan. So just a quick breakdown of the eligibility here. So the current eligibility criteria for startups is that you must be headquartered in Ontario, Manitoba, or Saskatchewan. You must be CCPC, have less than 500 employees, and the IP protections to be acquired must be owned by the startup and not the individual. Moving on to tier types here. There are 3 different tier types. So the first is awareness and education. So this is for startups that are fairly new to IP. And so this gives them access to informational resources, workshops, and programs to understand the use and competitiveness of IP. Then we have tier 2, which is developing strategy. So this is for startups in need of an IP strategy. So startup then is connected with an IP service provider or an IP expert who will provide them coaching and information to help access resources required to develop IP strategies. And then the third and lastly is our implementing strategy, IP strategies tier. So this is for startups with implementation ready IP work. So a startup again is connected with an IP service provider who will take the necessary steps to protect their IP and enable them to achieve their business goals. And then just some information about our post-session survey. This will be sent out to you in an email after the session. So please do take a few minutes to fill this in. By providing us with your feedback, you're helping us to ensure that the content of these sessions meet the needs of startups going forward. And then also the best way to stay updated with the Elevate IP updates is to register a profile on the portal. And this will give you access to all of our tier 1 offerings, so workshops, training sessions, etc. And then you can also apply for tier 2 or tier 3 on there. Now I'd like to introduce Joanna Ma to deliver the session. So Joanna Ma, an IP strategist and patent lawyer at B&P, specializes in patenting software-driven technologies with an electrical engineering background. She advises clients on developing and aligning IP portfolios, commercializing IP rights, and enforcing them. Joanna is actively involved in innovation hubs, a frequent speaker in IP strategy, and has co-authored chapters in global guides and startup law publications. Joanna is also one of our signed IP lawyers in the Elevate IP roster of lawyers you may work with if you choose to apply for the Tier 2 or Tier 3 services in our region. So just a note that the slides will be available after the session. The session is also being recorded, and Joanna is more than happy to take questions in between. So feel free to pop them in the chat. We'll keep track of that. And then also, if you'd like, if you have any burning questions, please feel free to unmute and ask those questions right away as well. Over to you, Joanna.
Thank you, Rochelle. Just gonna share my screen here. Okay. So hi, everyone. Thanks for making time to listen to this conversation today. We have a small group, so feel free to interact as we go through the presentation. There's some polling questions in the middle where I hope you'll interact and then engage, and we'll make it a fun 1 hour conversation on IP. So just very briefly on Breskin and Parr, we're an intellectual property law firm, which means we specialize only in intellectual property law. And so we only do patents, trademarks, copyright, designs, as well as anything on the fringe of IP. So we can help with privacy, data ownership, anything within agreements related to IP clauses, licensing agreement down the road as well. So we have an office in Kitchener-Waterloo. We're just at the Passport building down the road from Community Tech, as well as offices in Toronto, Mississauga, and Montreal. One of the things that we really excel at and really pride ourselves in is that we have a very diverse group of technical backgrounds. So my background's electrical engineering, like Rochelle mentioned, with a UBC law degree. We also have people with backgrounds in mechanical engineering, physics. We have a large group of life science with multiple degrees and all sorts of life sciences specialties. And so what we really do and pride ourselves in is that we make sure that someone who can at least speak your technical language is assigned to your work, and so that we can understand at a grad student level your technology and how to best develop an IP strategy for protecting that. We're also U.S. patent agents as well as Canadian patent agents and Canadian lawyers, which means that we can represent Canadian applicants directly before the U.S. Patent Office. And so that helps with some cost savings as well as a more holistic approach to IP management. So that's just really briefly about myself and the firm. And I'm going to start off with just a quick outline of what we'll be doing for the next hour. We're going to just introduce the patent process as we engage with you on and how to develop an IP strategy, some polling questions, as well as going through the different types of filings. And those are going to be more keywords you may hear as you engage with the process, and some example filing strategies to guide you in the next steps. So to start off with the patent process, this is a typical flow of what you may encounter when you try to develop a patent application, especially with our firm. So when I mentioned that it's important to make sure that you're working with patent professionals who have at least a technical background that can understand at almost a grad student level the technical terminologies. It's really important because at the first stage, most of the time, we work with you to understand your invention. So that part is important because we need to understand where you are in your invention development at this point, as well as looking forward to where your technology may evolve, because the patent term is 20 years. So you want to make sure that you cover as much as possible in your current patent application. So that's the stage one of patent, defining your invention. The second stage, it's dotted there. It's optional. It's a really good risk assessment in terms of understanding where your risk may be or your barriers to you obtaining broad patent protection. So the idea is that we would mimic what a patent examiner will do at the examination stage there by conducting a patentability search. So under Elevate IP, that's a requirement for you to be funded for a patent application down the road. And for today's focus, it's the next stage. Once we land on an invention, we conduct a search, and we land on a concept that we think is going to be possible or viable down the road during examination that will lead to a patent, we then help prepare and file a patent application. So what's key to understand and appreciate is IP rights is jurisdictional. So patent specifically, if you want patent rights in Canada, you need to file for a patent application in Canada as well as in the US if you want protection in the US. There are ways, and we'll explore that through this presentation, of extending the decisions you have to make in terms of specific jurisdiction. There are ways to extend when the costs are incurred as well too, and there are advantages or disadvantages of doing one or another. We'll explore those concepts today. And to finish off the patent process, after you prepare and file, depending on the jurisdictions you're engaged with, examination will happen. An examination is when an examiner who also has a technical understanding or technical degree education that is aligned with your technology will pick up your application and evaluate it and see whether it qualifies or complies with the requirement for obtaining a patent. And most of the time you can get to a good negotiation point where you agree, both sides agree to what it is, and then that's when it's allowed, and it's a matter of paying the issue fee depending on the jurisdiction of where you're engaged with. But for the purpose of today, we're going to talk about the different filing strategies once we land on a concept and you want to pursue a patent for that. So I know IP strategy is a very hot topic right now. It's a very good buzzword, but what does it really mean for a tech company like yourselves? So I think it's important to really remember that IP is not a standalone item. It needs to be aligned very well with your business needs. And so as your business evolves, your IP strategy likely need to evolve with that. But to start off, often I ask my clients to think about really what is your competitive advantage? What makes you different? So first off, like what makes your company do best? What makes your company unique? And think about those questions as we go through this presentation too, because these questions are going to be the driving force in terms of how you develop your filing strategy, because you need to decide exactly what jurisdictions matter most for your company. And also, how do you pull your competitors' clients to you? How do you distinguish, or how do you market yourself? What are those distinctions? And so at the end of the day, focusing on protecting what makes your company different, so that delta is important. So it might be that your company is in the space, you're first to market, you have garnered a really good reputation for your services and wares, but it's not really a technology that you have developed. Instead, it's your branding that's the focus. And so your IP strategy may focus more so on the branding, but over time you evolve and develop a technology that has become more important for your business. And so you might pivot a little bit and focus on protecting your patent. It may be that you focus on trade secret alternatively, because there are ways that you do your business or offer something that you're able to protect as a secret without anyone being able to easily reverse engineer. So recipes are typically a really good way of protecting with trade secret. So keep these questions in mind through the presentation and think about what makes sense for your company. And that will help you develop your IP strategy and then focus on which type of IP may be most relevant, or a couple types of IP may be most relevant. And then over time, what jurisdictions may make sense the most. So IP strategy framework typically is a combination of some of these concepts. For startups or scale-ups, likely the defensive approach and financial are most key. In terms of defensive, you're developing IP so that you have IP, like IP filings, that you can later use to block and move and keep competitors away from your moat effectively. And so most of the time with clients at the startup scale space, we just focus on getting them IP filings, IP patents, trademarks registered, and then we focus on some of the other elements. Financial it's a key thing too, especially for scale-ups when you're looking to get investors to on board and to show them like your key differences. So it goes back to the questions like what makes you different and what is your pitch deck? How are you explaining to your investors that you're worth their money? And so most of the time, if you have some patent pending status, trademark filings, or at least the idea of IP strategy developed, that is very key to making sure that, you have a difference that they can invest into. So over time, it likely will evolve into more of an offensive approach. Most of the time, you don't really go into full-blown litigation with your competitors, is the fact that, you have IP, they likely have IP. Let's talk about ways to cross-license or, work together and not sue each other. And it's a way of defending against the more expensive lawsuits later on down the road. And then eventually down the road, another way of generating revenue is through IP. You can license your patents and potentially generate more avenues of revenue based on potentially your use of that technology in different industries that you haven't really thought or want to get into, or potentially different jurisdictions down the road as well too. And then strategically over time, you can try to control a greater share of the market through your IP. So these concepts are really important too in developing where you may want to file your IP, your patents, for example. And so keep these in mind as well too as we explore the filing strategy down the road. So generally, when you're developing an IP strategy, these are the top line arrow there is really the main kind of steps that you would want to consider. So the first, again, is identify the business objectives and your IP assets that currently exist right now. It's important to align your IP strategy with those business needs. And so for today's conversation, because we're focused on filing strategy, what I have put in red arrows is likely the core elements that you should consider. What are your business objectives? Are you trying to just commercialize in North America? Like you don't really care about Europe, you don't care about Australia, maybe down the road in 20 years or 10 years down the road. So let's focus on making sure you're very well protected in North America. And then consider your commercialization goals. If North America is just your core focus, you don't really care about beyond that, then focus IP on North America. But if you're manufacturing in China, if you have a really good partner that you can use in Australia, for example, or even in Europe, you're actually having partnership, you're potentially licensing some of your IP to partners there, then you might want to think about ways to maximize potential breadth or potential ways of obtaining patent protection in those jurisdictions. And then down the next step, once you have identified the business needs surrounding your IP strategy, then you integrate and execute that. And that's more of an internal strategy, working with your IP professionals to create and develop that IP strategy for executing that plan. And then second, it's kind of like a circle. You go back to IP audit and realignment. That's when, over the next iterations of your business plans, you see whether your business objectives have changed. You review your IP strategy in view of where you are now as a business. It might be that your business have taken a pivot. You start off with one industry. For example, you were in the commercial real estate space, but for some reason your technology has found a new use and application in the mining space, for example. And then you might want to explore different ways to maximize your IP protection. It is more than likely that if you start with the commercial real estate space, North American protection is sufficient. But when you enter like a mining space, that's completely different. And likely you need to explore it well beyond just North America protection. And so think about the IP costs as well too. A lot of companies, as they scale up and get more sophisticated, they have different tiers of IP protection. Tier A may be more foundation IP that you want more broadly protected. So you file in North America, you file in Europe, you file in Australia, for example. But the tier B IP is less important. It's nice to have. Then you may focus that on more narrow jurisdictions. You might just file tier B tier B IP in North America, for example. So the IP cost will drive a lot of the decision making as well too, and also priorities. So think about that and consider these factors at the back of your mind when developing and considering what matters to you for IP strategy. And as I emphasized before, IP is really, it's a way to help increase the value of business. It shouldn't just be a cost. It will come with a cost, but over time, the IP, the patents you're filing should increase the return on value from everything you have invested. And so the idea with IP or patent filings is, make sure that initially you cover the foundation. What's the backbone? What's driving that difference, that delta of your company? Make sure that that's well protected. And then over time, as you obtain bigger market share, as you have more investments, think about ways to expand on the breadth. You might want to expand on the current portfolio, and there are ways to execute it and do that. Or you might file for additional patent filings or additional types of filings. So you might want to explore more design filings now because you have a more established product. And so you want to protect that product in a different way. And then over time, it might be just improvements on your existing technology that you want to cover. And so those might be more tier B patents that you file more locally, depending on where the company is. And so these are things to think about as we explore the filing strategy over time. So all of that said is summarized here in terms of how it affects your IP filing strategy. So when you're developing your IP strategy, you also consider where your jurisdictions of interest might be. So patent rights are jurisdictional, like I mentioned, and how to first start off with identifying which jurisdictions start off with is some of these key factors. What are your target markets? Patent rights give you the ability to stop someone else from doing that thing you have claimed as your monopoly in those jurisdictions, or to be brought into those jurisdictions for sale. And so think about where you intend on commercializing your manufacturing or potentially selling. So those markets should be at the top of your list. And then next thing is, where are your competitors? Where are your competitors selling? Where are they manufacturing? Where are they potentially licensing? And where are your potential future licensees? And consider over time, because again, patent rights are 20 years, right? So you want to at least look into the next 5 to 10 years. Where's your business going? Is it going to be short-sighted if you just retain protection in the US without considering Australia? If that's your, for example, in the mining space, and then potentially having incurred the cost of obtaining patent rights in Australia will be a really great investment down the road because the competition is there. Like you have excellent potential for licensing. Then that's something to consider as an option. And obviously, all of this you have to balance with cost and the budget of IP available to your company. And then we're going to dive deeper into the different types of IP or types of filings. And so the different types of filings will offer flexibility of timing and cost. There are ways of extending where you have to file over time and the cost associated with that. So I'll go into depth about those. But again, the different types will depend on funding available. Each type of filing will cost more. It costs money, and there will be costs in maintaining patents even afterwards. And as from the first patent process flow chart, you might remember that there's examination stage as well too, and there's costs associated with that as well. And the stage of invention. And so we'll go through some types of filings that you may have heard of, and that can be a bit more flexible in terms of enabling you to add in more developments over time, and your knowledge of the market, like where you may encounter more commercialization over time. And then finally, timing. Timing is a huge factor in terms of your rights or what's available to you. If you had made a disclosure prior to filing a patent application, you may be very limited in your rights. So that's something to keep in mind. That's something I really emphasize to my clients. Anytime you make a disclosure, before that, it's important to assess your risk of making that disclosure. And a disclosure in the patent world really is anything that enables another skilled person like yourself to be able to make that invention. So it needs to be a fairly in-depth disclosure, but it depends on the innovation as well too. So it's something to, before you do that, to have a conversation with a patent lawyer just to assess your potential risk if you make that disclosure. So at this point, I'm going to just engage with you a little bit with some polling questions. If you don't mind just raising, doing thumbs up or something like that on Zoom to answer this question. It'll be interesting for me just to get your thoughts on it. The question here is, I can't file for patent protection because I've already disclosed my invention in a white paper. Who thinks that, sorry, you're out of options? Just a thumbs up potentially. Or engaged. Awesome. Thank you for that. Who thinks that not necessarily, there may be options to explore, and which is a very lawyery answer. I guess no one there. And of course not, file away. I think no one there. Awesome. Okay, so I think, sorry, Rudy, it's more of a lawyery answer. It depends. So this goes to the disclosure aspect. So a white paper is a disclosure of the invention. Jurisdictions like Canada and US, there's actually a 1-year grace period from your disclosure for you to then still pursue a patent application for. Other jurisdictions like China and Europe, for example, they're absolute novelty countries, which means that the moment you disclose your invention, you're barred from obtaining patent rights. And so that's the gray area. It really depends on what was disclosed in that white paper, and we can assess that once you approach ourselves, our patent lawyer, and we can guide you on exactly what risk you may encounter if you pursue a patent still in Europe. Potentially you haven't disclosed your full magic or the secret sauce that you want to protect your patents, and then we might want to focus more so on that portion of the secret instead. So the second question and second last one is, can I obtain an international patent? So for show of hands, who thinks, yep, that's the way to go? Thumbs up there. No, okay, that's good. Depends on a number of factors. Rudy, thanks. And unfortunately, no such thing. Okay. So unfortunately, thanks, Rudy. There is no such thing as an international patent. There is a filing called the PCT patent application. So that's called the Patent Cooperative Treaty. It is a way for you to extend your decision making and extend the cost a little bit more. So the flowchart here, the timeline here is an example of an initial filing, and you can see this is the initial filing example. Here's a provisional patent application, and I'm going to go into more detail as to what that is. And then at the 12-month stage, you can file the PCT application. So with the PCT application, you will then actually get another 18 months for you to decide exactly where in the world you may want to file what's called the national phase applications. And so it is possible also to file at the first initial application as the PCT application, which means you'll get 30 months from that date to decide. And 30 months is a pretty long time. Like once you file the PCT or any initial patent applications, you are patent pending. And then from that point on, you can commercialize, you can engage with partners, you can test out the viability of your innovation. And at the 30-month stage, and probably even at the 12-month stage, you'll have a better idea of the success in certain jurisdictions. If you have partners in more international space, you'll have a better idea at that point. And then at that instance, around the 30-month stage, you can then commit to those jurisdictions. But I'm going to go into more depth as to what PCTs and professionals are right now. So feel free to ask any questions along the way if you have that. So the first type of filing I want to explore is called the U.S. provisional application. Provisionals are unique to the U.S. They are oftentimes considered to be an informal patent application with less requirements, and so it can be more informal. And that in some ways is true. Like they have less stringent requirements. Provisionals do not require claims. So claims section is this combination of legalese and technical language that define the scope of your monopoly. They also don't require formal drawings. But provisional applications are priority documents, so they need to be as detailed as possible in order for you to benefit from that priority. So generally, our practice is to prepare the provisional application despite having the less stringent requirements as if it's a regular application, so that when you file the provisional application at 0 months, you can have a good reliance that what you plan on pursuing protection for down the road has been sufficiently disclosed at this point. And so another benefit of provisional applications is that if you file today, so March 13, 2023, you have 1 year from that date before you have to convert it into the regular application. So again, like that lets you decide and decide on how much to commit in terms of funding for each of the different jurisdictions. At that point, you can either choose to file the US regular and just Canadian if you want to stick with Canada as North America as the scope of protection, or you may have over this period of time decided and encounter more success in different jurisdictions. So you might want to do a PCT application here at that 12-month point. Another benefit to provisional application is that during this 12-month period, you can update that provisional application to include any improvements. So in my example, if we file the first provisional application in March here of 2023, and then in June of this year, I make a significant leap in terms of development, another embodiment of my innovation, I can update that provisional number, the first provisional, include that improvement, file that provisional again as provisional number 2, and then at the 12-month stage, claim priority to provisional number 1 and 2 without having to refile a regular application. Because if you hadn't done a provisional application and you had just filed a regular application at this point, you would have to refile this as a separate application. And so that's another benefit of provisional application. You don't have to redo the process completely. You're able to update the specification and drawings within the patent application, and then still wait for that full 12-month period to claim priority from both. So that improvement you file in that provisional number 2 will have the June date instead of the March date. So that's some of the benefits of provisionals. They're really great use for early on development of technology. It's a good way of delaying the full decision making and allowing for some developments to take place before you commit to the full patent application. The second type of patent filing I want to explore is the PCT, as I had mentioned. So the PCT patent application is a way of obtaining, delaying the forms. Most countries in the world are party to it. Notable countries that are not part of it are listed here. There are some other ones as well too. But by filing the PCT application, example here, if you choose to do the provisional first and then the PCT at the 12-month, you would have another 18 months to then decide exactly which of these member countries you want to pursue. Instead of having to decide initially outright, like you want to file in China, Europe and Australia, for example. So the PCT is a really good way of delaying the full cost of each of these jurisdictions. It's more so even important for countries where translations are required. So Asian countries, for example, if you had filed them directly without the PCT, you would have to commit to the translation cost, which is quite hefty in some jurisdictions. So PCT is a really good type of filing to explore if you're considering filing in multiple jurisdictions outside of North America, typically. And you'll have a better idea once you see the cost upfront. PCTs are expensive as well. And just because it gives you the ability down the road to decide on other countries. And another benefit of PCT application is that once you file a PCT application, you will get an examination report down the road as well too. The examination report, unfortunately, is not binding on all countries. And so it might be that you get a very positive search report from the PCT office, but the European Patent Office disagrees and does their own thing. So it is what it is. Like it is a unified patent filing procedure, not necessarily an examination process. But if you receive a very positive PCT search report, there are ways to use that in certain countries to accelerate and save on costs in each jurisdiction. And I've succeeded on that with many of my clients, and that has saved a lot of costs and kind of helped accelerate their patent process a lot more. And going towards different types of US filings, and I'm presenting this more so that you have these keywords when you're entering the patent process. So unique to the US are types of filings called continuations. And what continuations are is that they're a way for you to broaden or expand on or alter the claims in the parent case that you have gotten an allowance on. And so, as I mentioned before, a patent application has a specification, which is a long, detailed disclosure of your invention, drawing section, as well as a section on claims. So the claims define your monopoly. So typically in the US, when you see companies very large portfolio, likely that they have retained the same specification and drawings, but have filed continuations to expand on the claims scope. Each time. So example is BlackBerry. They did a lot of continuations and their portfolio grew a lot because their specification and drawings was able to support different aspects of the invention, or they were able to support broader version of the claims. And the significant benefit of continuations and divisionals is that they still benefit from the earlier priority date of the parent application from which they were filed from. Divisional applications, they are not unique to US. They are available in many jurisdictions, but the practice is a little different for each jurisdiction. But generally, divisionals are where you have claims directed to another invention that was disclosed in your patent application. So the specification in the drawing section. So those are some keywords to think about when you're engaging with the process, just to help guide you on the next steps. So I'm going to go through some example filing strategies that may make sense to you as you engage with the patent process. So feel free to let me know if you have any questions, type away, or just raise your hand. The first example of filing strategy I present here is more of a typical one for startup Canadian-based technology company. The technology is still being developed and validated. So when I hear that from clients, I typically recommend filing a provisional application. So as you remember, a provisional is beneficial in that you have some flexibility in doing a second one, like a filing and adding any improvements you may have developed over the span of 1 year into a further provisional. So when I say a further provisional application is ultimately what you have filed in the provisional number 1, but with the improvement added in so that that improvement can have the priority date at the later time within the span of 1 year. And so at that 1 year point, that's when you have to convert the provisional applications. If you don't convert the provisional applications, they will just expire and never published as if it was never filed before. So for a Canadian-based technology company, I would suggest potentially focusing in on North America. And so at the 1 year mark, you can then file what's called a US regular application. So regular application, in contrast to a provisional, you would not be able to change the specification. You would not be able to change the drawings. But what you can change is the claims as long as it's supported by the specification and drawings. And so this regular application would claim priority to both US provisional number 1 and number 2, so that you have the early priority date of, for example, in March, and then again, 9 months later in December. And similarly, you do a Canadian patent application claiming priority to both provisional number 1 and number 2. And so this is more of a, startup, Canadian-based company. The technology is still evolving, you're still validating it. And so this is a typical approach I would suggest. I see a question from Ken here. Is there a place website to check up patents at whatever stage or have? Yeah, absolutely. Thanks for asking that. So I would suggest, I can Google Patents. Google Patents is an excellent resource. When we do searching, we kind of start off with that as well too, because it gives you a good starting point. When we do searching, we also subscribe to a couple of different proprietary databases that helps expand on the search. But Google Patents a great resource. You can type in subject matter, your competitor's name. One thing to keep in mind, though, when you file for patent application is that when you filed a provisional, if you never convert it into a regular application, it actually never publishes. So if your competitor just filed provisionals and they never convert, then you'll never see those. But when you file for a patent application, generally it's not published for 18 months. So if your competitor files something in the last 18 months, you will not be able to see that. Like, we won't be able to find that even during our searching. So that's a limitation of searching that we emphasize to clients.
Is there an alternative to dive deeper in? So let's imagine you think your competitor has a patent in the last 18 months. Can you go directly to the patent office or somewhere?
No, so if they didn't request early publication, it won't be published for 18 months. That's just how the law is.
Okay.
Yeah. Thanks for your question. So that's a filing strategy number 1. And a filing strategy, example filing strategy number 2 here is more for North American focus with a prior disclosure. So as I emphasized before, if you had made a prior disclosure, so sufficiently enabling another skilled person like yourself to make that invention, you would be barred from obtaining rights in certain countries like China and Europe, where they're absolute novelty based. So with a North American focus, prior disclosure situation, if the prior disclosure happened 12 months ago, you would need to, if you're looking to protect yourself patent-wise in US and Canada, within the 12-month period, or ASAP really, you would file the US as well as the Canadian patent application. So typically we would make sure that whatever was disclosed here is within these patent applications, as well as any other improvement that you may have done through this 12-month period to that technology. And so this is an example. Again, there are different potential ways of implementing that, but it will depend on the situation. And the final example filing strategy, number 3, which is a bit more complicated, is for more of a advanced scale-up companies. So an SME or a more established Canadian-based tech company, the technology is fairly developed. You have potential business opportunities outside North America, potentially Asia and Australia. And so I would suggest this type of filing strategy. And again, it will vary, again, depending on situation. But an example one would be, start off at 0 month with a provisional. The benefit of a provisional is that within this 12 month, you can keep updating that provisional with any improvements you make. And then at the 12-month stage, I would suggest doing a PCT application, because this company is likely to have business in in some countries in Asia and potentially in Australia. And so they want to enable a bit more decision making down the road 18 months later, where then they can decide exactly where in Asia they may want to enter. I typically recommend to clients to also do a US regular application at this stage as well too. US is a very big market, and most likely they will want patent protection in US. And the reason why is in the US, the examination stage, you're automatically entered into a queue once you file the US regular. And so depending on how busy the patent office is, sometimes you're able to get an examination report before you have to commit to the national phase entries from the PCT at that 30-month stage. Some art units, so when you file for a patent application in the US, it's assigned to a specific art unit based on the technology. And so at that point, you may have a better idea, the company may have a better idea as to how viable that technology is, how widely they want to go in the world. I've had clients succeed in obtaining patents well before the 30-month, and then they want to leapfrog from there in way more countries. And so as a result of that, there are ways to accelerate at no cost. It's called a patent prosecution highway. And so it's good to talk and discuss this with your patent professional. And so once you file the PCT, you will have that 18 months to decide exactly which countries you would want to go. So in this example, they may have decided just to enter in China instead of other countries, multiple other countries in Asia, Canada, and Australia. Remember, they already have the US regular pending. So as a reminder, like the notable features of PCT is that you do get an examination report. It's non-binding to all the other countries that you may want to enter into. But one significant benefit is that you could use that PCT search report through an acceleration path called the Patent Prosecution Highway, the PPH, and that has been very positive even in the US for them to accelerate and think look more positive to your patent application. National phase entries, so the national applications are examined by its national patent office. So again, the PCT search report may not be used in those offices. Europe typically do not follow any search report generated by another searching authority. So that's something to keep in mind. And it's a really good, PCTs are a really good way of deferring costs and decision making. And so it helps you streamline the filing process too, especially if you have a US regular in parallel. So that's the example filing strategy. I see another question from Ken there. How is disclosure thought of in the context of a capital raise, investor deck, high level pitch? Yeah, like I get what you're saying. And so it depends on the situation. And so I emphasize that the disclosure for it to be a disclosure within our patent world is it needs to be sufficiently enabling for someone else to practice what you want to protect in your patent. So in a business, for example, an AI application, for example, and what is shown and just described highly at a high level at an investor deck is that you can apply an AI model to generate a recommendation. And what you have shown is just a block diagram. That likely isn't sufficiently enabling because you can't even obtain a patent for that. But in the case where it's more of a device that you have developed that you want to pursue patent for, and you show the schematics, you show exactly how the device is configured, like that would be a problem. So it depends on the situation, depends on how extensive it is. The trouble though is depending on the type of investor conversations you're having, you might be led beyond what is in your deck. Like, so for the more sophisticated technical investors, they may start asking more questions. And so that's usually where I'm wary about. It would be great if, in general, anything under a non-disclosure agreement, an NDA, you're protected. That's still confidential. That's not an enabling public disclosure. So having an NDA marking all your disclosure with privilege and confidential and proprietary is important, and that will protect you. But at the end of the day, I would suggest that any disclosure, any discussion of your invention be made with caution. Like anyone you talk to could, if they're not under NDA, at least they could be going out and talking about your invention to their buddy, and then that could, proceed down the line to something else. So as a lawyer in me, I would say, make as little disclosure as possible until you have a patent filed, or at least you've talked to a patent lawyer and understand the risk associated with that.
Okay. Yeah, thank you.
You're welcome. So that's the end of the presentation for today. So thank you so much, and I'm happy to take on any more questions.
Yep, feel free to unmute and ask any questions or pop them in the chat. Either way.
I've reached my question limit.
Thank you. They were really great questions.
I'll give it a little.
Hi.
There we go.
Hello.
Yes,
Hi.
go ahead. Hi.
Hi. I process a patent in PCT, and um, I claim it almost like a 12 things, and it's they did some like examination and said two of them is not novel. Is there any uh, is there any way to change or update for this?
And so just to clarify, you have a PCT application, and then you receive a search report from the PCT office, and they're saying it's not novel or it's obvious. Is that the situation?
Yeah, it's like I claimed the 12, and they said there's a 4, and 3 and 4 is related to 1 and 2, and 1 and 2 is not normal.
Yeah, so I'm guessing the claims they have identified. There is a way of responding at the PCT stage, but again, like because it's not binding on the jurisdictions that you may enter down the road. We typically don't recommend spending cost on that unless it's a really clear cut, like very relevant reference. So you can review the reference and see how relevant it is. If you can develop a very strong argument against it, like you may choose not to respond at the PCT stage and see if the other patent offices you engage with down the road uses the same reference. They may, the Canadian, I'm guessing you file in Canada. The Canadian Patent Office will likely follow that opinion. US sometimes or sometimes doesn't. European Patent Office is unlikely to follow the Canadian opinion. So at this stage, it depends on the situation, depends on how relevant. I think it depends on a more thorough discussion on that.
Okay. Yeah, that one is Canadian decision. It's like a Canadian opinion, and I filed that one for US and Canada, and after that I decided to go to the PCT, and after that in last year they gave me the examination, said there's that situation is happened. So it's a little bit of crazy. I have no idea, because in the first time the US and Canada said that one is novel, and go to the PCT that said it's not novel. So yeah, it's really fun.
Yeah, so that's why it's important to manage each of them. It depends on the situation, and then typically the Canadian office would follow its opinion even at the PCT stage. But I'm guessing your Canadian case has an exam, because in Canada, when you file for a patent application, you still also have to file a request for examination 4 years down the road. So I can't really comment on it until I've seen the case. But yeah, it's typical that the patent examiners reject it. That's kind of their job. And so it's our job to go back and negotiate that.
Yeah, yeah. And because my things during the COVID, I'm not doing any test of my design is only designed by SolidWorks. So yeah, maybe they concern about that things like a approval.
Yeah. Did you draft the patent application on your end, or did you have a patent lawyer prepare?
I go through with a company in Toronto.
Oh, so a law firm.
Yeah.
Okay. Yeah. So typically they should be able to guide you on the process and guide you on how best to respond. So typically, when you work with our firm, we would report any examination report to you, advise on recommended paths, the costs associated with each, and go with that. So I think typically most law firms do. And so I would suggest engaging with them and discussing on that. They should be able to offer insight as to what it is. Like it's a very, the office actions you get, the examination reports you get, they're very convoluted. It's a very boilerplate, and then you have to just look for certain sections. And so it requires a little bit of guidance, and it's not very client friendly, unfortunately.
Okay. Okay, gotcha. Thank you.
Any other questions?
Sure, I'll jump in.
Go ahead.
Thanks, Joanna, for this. Can you elaborate a little bit on the constraints and difficulties and the differences, compare and contrast, in patenting software in Canada versus the US? Because software is, certainly with Communitech and the AI developments space, it's super hot. There's tons of applications pending, but exactly what's getting through to the finish line is hard to determine. And the rules of the game are different in the Canada and US. So maybe you could educate us a little bit on what's working and what isn't and why.
Yeah, thanks. Thanks, David. That's a really good question. It's actually really up my alley. My practice is hugely in software. So as context, the law on software patents in the States evolved like substantially since 2010. That's when a case from the Supreme Court, Alice, came out. Back before that point, you were able to get very broad patent claims on related to software applications. But after that, things changed completely. Since then, we've learned a lot from the US Patent Office as well as a lot of case law. Effectively, in order to have a strong case for a software patent, you need to focus on a technical problem you're solving. So a technical computer-ish problem that you're solving. And the claims themselves need to be a technical solution. So it's very important that you have computer processing elements, ideally, and you need to focus on exactly what's happening at the black box end, for example, if that's the innovation. And then focus the claims on, it can't just be receiving data, changing that data to another color and, going with that. It cannot, typically needs to be more than 4 lines. Like before the case in the Alice case in 2010, you were able to probably get patent claims, the independent claim, that are less than 4 lines long. But nowadays, you have to give much more context as to what the technical solution really is. You need to detail exactly how you're applying an AI model, for example. So we need to work together from the patents professional side as well as the client to understand where your invention really lies. Most of the time in the AI space, which I do quite a bit, we need to figure out, like most of it's not the data model you're protecting. Potentially the way you're generating the data model, the training part of the data could be inventive. Then so we have to focus in on that. And we have the claims. It goes into detail what you're doing with the claims, going to the data and how you're generating that. And most of the time it's applying the machine learning model, the data models, in making certain recommendations. So specifying it to a specific industry, specific applications, and then playing in the flavors of specific ways of using it and adapting that recommendations has been very helpful. And then having in the application itself the technical problems you're addressing. So the context in which you're facing, your client is facing, and what it is that this solution helps to solve from the computer side. So it needs to be more than just, facilitating a way to make it faster. Like the efficiency part, it's good too, but your claims then need to focus on why it's more efficient and the technical solution and the computer reasons as to why it is. So that's the US approach. Canada recently has changed a lot. They used to be at one point following the US practice. I think if you are in a good spot in the US and you have focus on the technical solution in detail within your specification as well as the claims, you should be in a pretty good place with the Canadian office. What the Canadian office has recently done in the recent cases, Benjamin Moore, which has gone through appeal, and now it's at this really weird spot where it's ambiguous as to what the legal test is and patentable subject matter related to software, is the claim themselves was a little bit ambiguous. It was the Canadian office still stands very opposed to more business method claim sets. So it's going back to the black box where, receiving data and changing it to a different color. Like if you're just doing a business flow and automating that process, and you're not hiding that well with your claim, you're not bringing in more technical language, you're not bringing in enough technical differences, then they're not going to allow that. So Canadian-wise, it does need a lot more technical disclosure, and that's why I emphasize it's really important to make sure that you're working with professionals that can speak your level of technical language. And so, yeah, sorry, that's a very long-winded way of answering that. It is possible to obtain software patents in Canada and US, but it does require a lot more detailed analysis.
So as an example, in the era of AI, if you're consuming data and you're applying significant logic to the inputs, scoring algorithms or algorithms broadly, does that look and feel like a technical solution, or what constitutes a technical solution within the sphere of AI?
And
Yeah,
Joanna, maybe a shorter answer to this one. I'm just being mindful of time here for. Yeah.
We're getting into that scope, like that's getting closer. It just can't be like I apply this model to generate a recommendation. Like you need to have more details as to what the solution is. But I'm happy to take this offline and feel free to read it.
All right. Time moderator has spoken.
Sorry about that, Rochelle.
No
No,
worries.
I get it. I get it.
Thank you. Thank you so much, everyone, for joining today and for your great questions and for being engaged in the session. Thank you, of course, Joanna, for joining us and presenting. Just as a reminder, there will be a survey that will be sent out shortly after we end here. So please fill that in. And we have another few sessions coming up. So keep an eye out for those in April, May, and June. And we'll see you at the next one. Thanks so much.
Thank you.